Good afternoon, Judge Gorven.
Good afternoon, Chief Justice and members of the Commission.
Are you well?
I am, thank you.
I know that I wasn't relaxed appearing before a body like this except for my last interview. Are you relaxed?
I'm fairly relaxed, thank you, yes.
All right. When did you become the judge of the KwaZulu-Natal Division of the High Court?
With effect from November 2008, just over 9 years ago.
And how long after your appointment were you then afforded the opportunity to act at the Supreme Court of Appeal?
It would have been just short of 6 years. My first acting stint started in June 2014.
How long was your first acting stint?
My first acting stint was 5 terms. It was initially 4, but a person had to act in the Constitutional Court, and I needed to intervene and act in that person's position at the last minute.
And was there a subsequent acting stint apart from the 5 terms?
Yes, from December 2016 to September 2017, a further 3 terms.
Was that the last, or was there yet another acting stint?
That's my last one.
Yes. And is there anything about the workings of the Supreme Court of Appeal that you would have handled differently if you had it your way?
Well, I've got a long way to go before I have any say in that sort of matter.
I thought judicial independence covered you somewhat.
I think things work pretty well. It's an extremely busy court, and one has to get judgments out pretty quickly. There are often 70 appeals per term. So the system and method that they use there seems to me to be quite an efficient one. It mixes up panels of the different judges, so we all get to work with one another and to learn one another. People are designated to write a certain number of judgments and comment on those judgments in a thorough kind of fashion. So it's a good process in terms of making sure that some of the excellence that is required of an apex court emerges in those judgments.
Did circumstances as they obtained then give you a sense of belonging, or make you feel like an outsider, an intruder of sorts, in an environment best left for others?
Well, I think the first time I arrived there, I was a lot more nervous than the first time I appeared before this commission. But I was made to feel at home immediately. On my arrival, I met Judge of Appeal Matopo, who was also acting at the time. He took me under his wing and we became firm friends and still are. And all the members of the court welcomed me with open arms, gave me warm support and any assistance that I required, and affirmed me for what I was trying to do at the time.
And is it fair to assume that the quality of matters in which you were afforded the opportunity to write judgments was quite satisfactory?
Yes, thank you. Very much so. As a result, there are a number of reported judgments from my time when I was acting in the SCA, I think 14 altogether.
Is there anything more about your state of readiness that you either want to add on, or add to rather, or add because you did not state in the past?
I think I'm ready. I think the court is ready for me. I think I can bring to it a number of matters. I can bring to it a sense of unwavering commitment to the Constitution, so that as a judge, I will do what the Constitution asks and requires of me, and I will not do anything the Constitution does not allow me to do. I will not overstep the mark. I bring to it a very high work ethic. I do work hard. I find the work incredibly stimulating and most enjoyable. I find the collegiality at that court also stimulates me to better work. So I believe I'm ready, and I believe with the range of expertise, the range of exposure I had whilst both at the bar and as a judge, it can fill a gap in the Supreme Court of Appeal where a lot of people haven't had quite the range of exposure to matters, in particular civil matters, that I've had in the last, since I've been a judge and while I was at the bar, in fact. I bring also a sense of commitment to helping anybody who might need some assistance and collegiality as a whole, and that's what I would like to bring to the SCO on a permanent basis.
Yes. President Meyer.
Thank you, CJ. Good morning, Justice Gorven.
Good morning, President Meyer.
You were questioned at length during your last interview. I have sat in court with you on a number of occasions, and you have written judgments in matters in which I presided to enable me to discern that you are a hard-working, sound, and well-rounded judge.
Thank you very much.
I have also observed another important quality. You are very helpful to your colleagues, especially the junior ones, and that is very important in that court because we work in teams under very pressured conditions. I also know that you are deeply committed to transformation, and your CV and your last interview speak for themselves. Now, I just have one very grossly unfair question for you. There are 3 vacancies.
Yes.
There are 4 women candidates. We've all been saying for years that the number of women judges in the judiciary, especially in that court, is lamentable. Now, if at least 3 of the women candidates fare well in their interviews during this round, and they are found to qualify for appointment to that court, what would you advise the JSC to do?
You're wanting me to do your job for you as the commission. I would simply say this. Obviously, there needs to be full gender representativity and all sorts of other representativity, demographic representativity. My contribution, I believe, is to assist persons perhaps who would not have the kind of background and experience to me, including women judges, in finding their feet, in deepening their knowledge and understanding, in standing alongside of those people. If you find that there are 3 candidates, 3 women candidates, and therefore you shouldn't consider any males, well, that speaks for itself, and that's an easy answer to that question. But I do believe that even as a male, I can make a contribution to the transformation of that court, even by way of gender representativity, by increasing the expertise and increasing and standing alongside of people who might otherwise perhaps struggle in areas of the law that they're not 100% familiar with.
In the event that you are not recommended for appointment now, would you be willing to subject yourself to another JSC interview, or even act in the court to assist us as you've consistently done in the past, if the opportunity arose?
The first one of those is more difficult to answer than the second one. Of course I will act. Wherever I'm asked to act, I will most certainly act. Whether I make myself available for a 4th occasion, I can't answer that question right now. I'd have to think about it carefully at the time. I'd have to consult with colleagues, including those colleagues of all genders and races who have strongly urged me to make myself available on this occasion, along with the person who recommended me, who's also a black woman. So I'm afraid I can't really give a definitive answer to say I will come back. I'm not saying I will, I'm not saying I definitely won't, but I certainly would make myself available to act.
Thank you, Chief Justice.
Thank you, President. Commissioner Nokesi.
Thank you, Chief Justice. Good afternoon.
Hello, Commissioner Notiesi.
In fact, I only have one question. The Constitution of the Republic of South Africa instructs our courts to apply customary law where it finds application as a separate legal system without involving principles of the common law. And the Constitutional Court has insisted in this application in several cases. However, there's tendency by the courts to import the principles of common law in a customary law matter, to resolve a customary law matter, or to avoid dealing with a customary law issue. How best can we deal with this aspect in developing the customary law as a system of law?
Well, I think that's a very important question because it's one that's hardly reached the attention of courts up till now. It has to a certain extent. I think I'd like to say two things about that, or maybe three. The first is this. I have recently assisted Deputy Judge President Madondo in writing a book on basically getting the customary traditional courts up and running as the Constitution enjoins to take place. When I say I assisted, I proofread it, gave him some comments and so on. And once that system is implemented, then those courts will begin to apply the customary law, and if there are any review issues arising from that, the courts of our land will deal with those squarely, and that will come before us as customary law matters. Secondly, also Deputy Judge President Madondo and I were colleagues and friends at the bar. We remain colleagues and friends, but when we were at the bar, and he did a number of customary law matters. So I am familiar with some customary law matters, but I don't by any means regard myself as an expert in customary law. The courts, though, have this dilemma. Which of the two do you apply in any one situation? And I'm aware that, of course, even customary law is subject to the infusion of the principles of the Constitution, not the common law, but the Constitution, which infuses every aspect of our law, and that's been said to be so by the Constitutional Court. So that obviously is something which will need careful development and sensitive development, so that in fact that customary law, which is consonant or consistent with the Constitution, is applied instead of someone attempting to simply make use of the common law to exclude customary law where it's appropriate.
Thank you so much, Commissioner Casey. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge Gorven.
Good afternoon, Commissioner Nyambe.
It's just one question from my side. It's linked to the one of President Meyer. If you can summarize the rate of transformation of judiciary in our beloved country, South Africa, as an experienced judge.
Summarize the rate. The rate has been slow in absolute terms. What I'm saying by that is, obviously, if all other things were equal, this should have taken place a lot more quickly. But there were reasons for it based on the whole apartheid system, because many previously disadvantaged lawyers, both gender and race-based, were disadvantaged in their practices under apartheid for years and years and years, and were not subjected or exposed to the kind of range of work that a lot of the white lawyers were. And as a result, things developed in a very skewed fashion. They weren't able to develop the kind of expertise that was able to be developed by many others, by the privileged people such as myself. And I would think and assume that this commission, in making its appointments, has had to take into account the fact that If one simply drew a brush and said, well, we will simply transform into the situation that all of us want and the Constitution demands, it may well be that people would have found themselves under a great deal of pressure and stress and unable to cope. I'm not the person who's involved in the transformation process. You folk are, really. I would say it in absolute terms, it has been far too slow because we're still not fully transformed. But I suppose in realistic terms, maybe it's been a bit slow, but one can understand something of the reasons for why this commission has gone at that kind of pace.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Norman.
Thank you, Chief Justice. Good afternoon, Judge Gorven. Sorry.
Good afternoon, Commissioner.
Thank you. I've had the pleasure of appearing before you, both in the High Court and the Supreme Court of Appeal.
Yes.
But I just want to understand, how important was it for you to get a nomination from a black woman?
Well, when Ms. Gabriel wanted to nominate me on the first occasion, I was flattered. So it is important. It, for me, shows a stamp of somebody recognizing who I am and what I can bring to the bench, regardless of my gender and race. So it was important in that sense, and I felt deeply humbled that she was prepared to do it, not only one time, but 3 times. And she is a very competent practitioner, so I was extremely humbled.
Yes. And then following up on that, the fact that she had nominated you 3 times, my concern only relates to the last occasion, because she says in the nomination letter that she appeared before you in October 2017 in the matter that she goes to town about poor school children and all of that. But what I want to understand was, her opponent advised that she had nominated you twice when that opponent, together with her, appeared before you in October of 2017.
Yes, Commissioner Norman, that is correct. The occasion on which this took place was one where I made the disclosure to her opponent. It was an opposed application where I had read the papers carefully and prepared for the argument. And before the argument took place, I said to both the parties, I'm ready to hear argument, I'm ready to deliver judgment, but in this matter, if the judgment goes against either of the parties, there may well be an appeal and a long, drawn-out process. And I said, in the light of the fact that children are suffering, and it was common cause without any challenge that some young girls walking to school up to 20 to 25 kilometers per day had found people lying in wait for them because they knew that these girls would be walking to school alone or in couples, and had been raped and had been brutalized. I said, this is something surely which the 2 parties can put a stop to by resolving this matter and attempting to make sure that these young children are transported to school. I said, I will hear it, I will deal with it, and you can deal with the judgment as you feel fit. But I strongly suggest that the 2 sides talk to each other so that these children's plight can be resolved right now. And that's what the parties decided to do.
Yes. And then she nominated you again thereafter.
She
in
then nominated
November.
me again after that, yes.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Norman. Commissioner Mbo.
Thank you, Chief Justice. Judge Gorven, I just wanted to ask you a follow-up question on transformation. You know, you are the second person to sit there to point out, I think, the obvious fact that if we want proper transformation, we're going to have to give people an opportunity to do the work. It seems quite obvious, but for some reason, it just doesn't happen. And so I wanted to ask you maybe another difficult question, as President Mayo wanted you to ask a difficult question. It's difficult because maybe it should be posed to the Chief Justice and President Maya.
Yeah,
But-
Commissioner Mpofu, don't run the risk that the minister ran into.
Yes. The question is this, do you think that the bench can play any role in nudging the state and the traditionally white firms, the big firms, because I think those are the main culprits, in ensuring that black advocates and women, black women in particular, get access to the kind of work which will prepare them for the bench and other roles in the profession?
Thank you, Mr. Mpofu, Commissioner Mpofu. On a formal level, I'm not sure that the bench can do anything other than make pronouncements that this should be taking place. On an informal level, what can be done and what has been done and what I have done is to mention to practitioners that one rubs shoulders with that they should be looking to certain of the persons that they have ignored in the past and giving work to them on the basis that let's see how they do. And you need to be part of this transformation, because until people get work, the transformation can't take place. And I have done that, and I have done that successfully on a number of occasions, made those kinds of suggestions to practitioners with whom I rub shoulders either socially or after they've made an appearance in court, or when they've come to take a consent order in my chambers, or whatever it might be. And I think certainly the bench must be doing those kinds of things as regards representation and practitioners.
Yes. Thank you. Thank you, Chief.
Thank you, Commissioner Mpofu. Commissioner Malep.
No, I just want to make a follow-up on that question of the disclosure. When you were asked that, did you disclose to the parties that the other one nominated you? You said yes, and then you went on to explain something that was not related to your answer. So when you disclosed that the other one nominated you, what was the attitude of the other party?
Well, the disclosure, why it was relevant, Commissioner Malema, is because I didn't, in fact, hear argument in that matter. So I didn't make any decision in that matter. Ultimately, the parties agreed that they would resolve it by getting transport for those school children. That's the relevance. I didn't go ahead and hear the matter. If I had gone ahead and heard the matter, I would have asked the other party whether they wished to bring an application for my recusal, and I would have dealt with that application.
The question was, what was the reaction of the other party? Was it silence? Was it an objection?
There was no objection. To be absolutely honest, I can't recall. They seemed to be very happy for me to handle it and to make that suggestion.
Yes. What raised my interest was alluding to the possibility of an application for recusal.
Yes.
I was wondering what would have necessitated that. But
What-
anyway,
What would have necessitated that is if I'd gone ahead and heard the application, because at that stage the hearing hadn't taken place. Before the argument took place, I made the suggestion, and they took up the suggestion, and no argument took place in the end, except by way of a consent order at the end of it. But if argument had taken place, I most certainly would have invited any application for a recusal that they might have wanted to bring.
I don't understand that. If another person has got no objection, why would it have been necessary to bring an application for recusal? Why would you have invited that application in circumstances where there is no objection, there is happiness?
Well, there wasn't at that stage I didn't ask the parties, what is your formal response at that stage? So I don't know what their formal response was. If the argument had continued in court, I would have asked for a formal response, in which case, hopefully, they would have said they didn't object. If they had said they objected, then I would have said, well, then, do you need time to bring a recusal application? And if they'd said yes, I would have given them time.
Yes. Commissioner Masuku?
No, Chief Justice.
is it the follow-up?
No, it's my question, it's not a follow-up. You are
Okay.
follow-upping my question.
Oh, I thought you had abandoned it.
No,
All right, okay, carry on,
No,
Commissioner.
uh,
I'm sorry, I thought you were done.
No.
Oh.
No, my interest is that he says he disclosed the relationship and then did not deal with the matter because if he had dealt with the matter, he would have then asked if the parties are comfortable. But you dealt with the matter.
No, I didn't.
No. You dealt with the matter because you told them your relationship with the other party. And you didn't stop there. You proceeded to give them an advice. Because that is dealing with the matter also, as a judge.
Commissioner Malema, I disagree with you. I was dealing with the matter in the sense of inviting them to consider resolving it. That's different to dealing with the matter by way of making a decision in the matter and hearing argument. And that is what I did not do, and that is what a judge is called upon to do if necessary. I agree that I was using my office as a judge to see whether or not they could take time to resolve the matter. They took up the invitation without any protest from any side, and they did.
Commissioner Masuku?
Thank you, Chief Justice. Good afternoon.
Good
Judge
afternoon,
Gorven.
Commissioner Masuku.
In your answer to President Maya's question about whether or not you, well, I'm not sure, in fact it was Commissioner Nyambi, about the pace of transformation, you said that transformation is going very slowly. Do you consider the slow pace of transformation to be a threat to the legitimacy of the judiciary and possibly a threat to judicial independence?
Sorry, possibly a
And possibly a threat to judicial independence?
It's very hard to know what the perception of the community is as to the state of the judiciary. It obviously could be a threat. If there was an untransformed judiciary over a long period of time, and there was a sense that the judiciary was being stacked unevenly with certain people, your public perception might well think that there's a problem with the judiciary and believe that the judiciary was not independent and there was some kind of skewedness in the judiciary.
Last question. So if there were three black judges who were appointed who could be appointed to the Supreme Court of Appeal, your answer should be easy in respect of whether or not you would give up the opportunity to be appointed there just to advance that particular constitutional objective of transformation. Am I correct?
Yes, if those persons can bring to the court similar expertise and experience to me, I would have to agree with that. And as I said to President Maya, it's easy. If this commission decides that there need to be 3 women judges appointed, well then that's the end of the matter.
Thank you. Thank you, Judge Gorven. You're excused.
Thank you very much.